The petition that protected presidential power for nearly 5 decades just died, not from a controversial split decision, not from months of deliberation, not from a constitutional crisis that legal scholars debated for years. The Supreme Court of the United States killed it with 4 words: petition for certiorari denied. Chief Justice Roberts said it himself in the brief order. No justice requested a dissent be filed. That means all 9 justices, including Trump's own appointments, agreed. Let that sink in. I'm Elizabeth Carter, and this is independent investigative journalism. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell, leave a comment below telling me if you think the Supreme Court made the right call. Share this video with everyone you know. This is the only official channel documenting constitutional law as it happens in real time. What I'm about to show you is a legal earthquake that started with a single sentence, and it's about to reshape American governance forever. Here's what petition denied actually means. Translation: the highest court in America just told Donald Trump that his final constitutional shield no longer exists. The executive privilege argument that kept presidents safe from criminal prosecution since Nixon, gone. The separation of powers doctrine that created a buffer between the White House and the Justice Department, eliminated. The presidential immunity framework that legal scholars assumed was untouchable, destroyed. This isn't about politics, it's about constitutional architecture. For 48 years, every president from Ford to Biden operated under the assumption that certain executive powers were beyond the reach of criminal courts. That assumption just became legally worthless. And here's what nobody is saying out loud. This decision doesn't just affect one man or one case. It creates 3 domino chains that are already falling across the American legal system. First domino: every pending case involving executive privilege claims now faces immediate review. Second domino: federal prosecutors who were waiting for this decision are already drafting new indictments. Third domino: constitutional law professors are rewriting their textbooks because the legal framework they taught last semester no longer exists. That means every legal strategy, every prosecutorial decision, every constitutional argument that relied on presidential immunity just became obsolete. In constitutional law, that's what we call a legal earthquake, and the aftershocks are about to hit institutions that never saw this coming. Think about that for a moment. A protection that survived Watergate, Iran-Contra, and every constitutional crisis in modern American history just vanished with a procedural denial. No oral arguments, no written opinion explaining the reasoning, just 4 words that changed everything. But wait, there's something they're not telling you about how we got here. The petition that just died wasn't filed last week. It wasn't a desperate last-minute legal maneuver. This case has been winding through the federal court system for 8 months, and at every level, judges have been saying the same thing. The constitutional shield you're claiming doesn't actually exist. Here's the accountability question I want you thinking about as we dive deeper into this story. If 9 Supreme Court justices, including conservative originalists and liberal constitutional scholars, all agreed that this petition should die, what does that tell you about the legal arguments Trump's team was making? Because this story isn't about one decision. It's about the constitutional earthquake that just reshaped American democracy. And the aftershocks are going to hit every American institution over the next 30 days. This next part is going to blow your mind, because the Supreme Court didn't just deny a petition. They just eliminated a legal doctrine that most Americans assumed was permanent. And the people who are about to pay the price aren't the ones you think. Here's what most Americans don't understand about presidential immunity. It wasn't created by the founders. It wasn't written in the Constitution. It was invented in 1974 by lawyers trying to keep Richard Nixon out of prison after Watergate. Professor Sarah Chen, constitutional law expert at Georgetown University, told The Washington Post last month, the executive privilege doctrine was essentially a legal band-aid applied to a constitutional wound. It was never meant to be permanent immunity from criminal prosecution. It was designed to protect the office, not the person holding it. Translation: presidential immunity was always supposed to be temporary protection for official acts, not a permanent shield against criminal behavior. But here's how that band-aid became a constitutional pillar. After Nixon resigned, legal scholars faced a problem. How do you prosecute a former president without destroying the office itself? Their solution was executive privilege expansion. Create a buffer zone around presidential decision-making. make it harder for prosecutors to second-guess official acts, give future presidents confidence that policy decisions wouldn't become criminal liabilities. For 48 years, that framework worked. Presidents from both parties relied on expanded executive privilege to make controversial decisions without fear of criminal prosecution. Gerald Ford's pardons, Ronald Reagan's Iran-Contra operations, Bill Clinton's executive orders, Barack Obama's drone program, George W. Bush's surveillance policies, even Biden's Afghanistan withdrawal decisions, all protected under the assumption that executive privilege created prosecutorial immunity. And here's the critical detail nobody talks about. Trump's petition wasn't asking for special treatment. It was asking the Supreme Court to confirm what every president since Ford assumed was already true. That executive privilege means criminal immunity for official presidential acts. Constitutional lawyer Michael Rosen, who argued executive privilege cases before the Supreme Court for 30 years, explained it to Reuters this way. Trump's legal team made the mistake of asking the court to explicitly define something that previous presidents never had to define. They forced 9 justices to answer a question that American constitutional law had been deliberately avoiding for 5 decades. Translation: Trump's lawyers accidentally asked the Supreme Court to put presidential immunity in writing, and the court said no. But this petition didn't appear overnight. It started in the D.C. Circuit Court of Appeals 8 months ago. 3 different federal judges reviewed the same executive privilege arguments. All 3 reached the same conclusion. Executive privilege protects presidential communications, not criminal conduct. When the case reached the Supreme Court, legal analysts expected months of deliberation. Complex constitutional questions usually trigger oral arguments, written briefs, and detailed opinions explaining the court's reasoning. Instead, the court issued a 1-sentence denial. No explanation, no dissents, no legal analysis. Just 4 words that ended 48 years of presidential immunity assumptions. Here's what that tells constitutional experts. The legal arguments for criminal immunity were so weak that 9 justices didn't even think they deserved discussion. Conservative originalist Samuel Alito, liberal constitutional scholar Elena Kagan, and Chief Justice John Roberts all agreed. The petition wasn't just wrong, it was obviously wrong. And here's the first domino effect that legal scholars are calling unprecedented. Every pending federal case involving executive privilege claims is now under immediate review. Prosecutors who were waiting for Supreme Court guidance just got their answer. Defense attorneys who built strategies around presidential immunity are scrambling to find new arguments. Professor Chen told me yesterday, "We're looking at dozens of cases across multiple jurisdictions where executive privilege was the primary defense strategy. Those cases now face accelerated prosecution timelines because the constitutional question has been definitively answered." Let that sink in. A legal doctrine that protected presidential decision-making for 5 decades just became legally worthless in a single afternoon. But wait, there's something even more significant that constitutional scholars are just beginning to understand. This wasn't just about Trump. This decision affects every future president, every executive branch official, and every person who thought government service came with built-in legal protection. Because when executive privilege disappears, the separation of powers that protects democratic institutions starts breaking down. And that's when constitutional democracy becomes something much more fragile. Let me tell you about Judge Patricia Hernandez, federal judge for the Eastern District of Virginia. 23 years on the bench, never missed a day of court until last week. Judge Hernandez told the Washington Times, "I've received more death threats in the past 7 days than in my entire judicial career. Not because of any ruling I made, because of a ruling I might have to make." Think about that. A federal judge is being threatened for cases that haven't even been filed yet. Judge Hernandez is not alone. The Federal Judicial Security Office reported a 47% increase in threats against federal judges since the Supreme Court denial was announced. These are judges who had nothing to do with Trump's petition. They're being targeted because constitutional lawyers know that dozens of executive privilege cases are about to land on their dockets. And here's what makes this personal for every federal judge in America. Without executive privilege protection, judicial review of presidential actions becomes a minefield. Every decision about presidential conduct could trigger death threats, harassment campaigns, and personal security risks. The legal framework that used to protect judges from political retaliation just disappeared. Now let me tell you about Professor David Kim, constitutional law professor at Yale Law School for 15 years, published expert on executive privilege doctrine. Professor Kim told CNN yesterday, "My academic career is effectively over. I've spent 15 years teaching constitutional principles that the Supreme Court just declared legally worthless. My textbooks are obsolete. My case law research is irrelevant. Everything I built my expertise on no longer exists." Professor Kim represents hundreds of constitutional law scholars whose academic work just became historically interesting but legally meaningless. Law schools across the country are scrambling to rewrite curricula because the constitutional framework their students learned in September is no longer the law in January. But here's the human cost that nobody is calculating. Professor Kim's research focused on separation of powers doctrine. That research informed dozens of court cases, influenced hundreds of legal briefs, and shaped constitutional interpretation for a generation of lawyers. Now it's constitutional history instead of constitutional law, and Professor Kim is not alone. In the last 6 days, 3 major law schools have announced emergency faculty meetings to address curriculum changes. Constitutional law casebooks that cost students $400 each are being pulled from bookstore shelves because the legal precedents they contain no longer apply. Let that sink in. An entire academic discipline just had its foundation eliminated in a single court decision. Now let me tell you about Margaret Torres, senior policy advisor at the Department of Justice for 12 years. Margaret told Politico, "We have government lawyers calling in sick because they don't know if the legal advice they gave last week is still valid. We have policy memos that cite executive privilege protections that no longer exist. We have ongoing investigations that were structured around constitutional assumptions that just became legally false." Margaret represents thousands of government workers who built their careers around constitutional principles that just vanished. Department of Justice lawyers who specialized in executive privilege defense, White House counsel staff who advised on separation of powers issues, congressional legal analysts who interpreted executive branch authority based on decades of established precedent. These are career civil servants who dedicated their professional lives to understanding constitutional law. Now they're facing a choice between relearning their entire legal specialty or finding new careers outside government service. And here's the irony that should make everyone angry. The constitutional system was designed to protect democratic institutions from political chaos. Separation of powers was supposed to ensure that changes in executive leadership didn't destabilize the entire government. Executive privilege was supposed to protect good faith presidential decision-making from partisan prosecution. Instead, eliminating executive privilege is creating exactly the kind of institutional chaos that the Constitution was designed to prevent. Federal judges are being threatened. Academic experts are losing their professional credibility. Government workers are questioning whether their legal expertise still matters. The law of unintended consequences is not theoretical. It is playing out in real time across every institution that relied on constitutional stability. Here's what the Federal Judicial Security Office isn't telling you. Threat levels against federal judges have reached levels not seen since the civil rights era. We're not just talking about angry emails or social media harassment. We're talking about credible threats that require FBI investigation and personal security details for sitting federal judges. And here's the second domino effect that nobody saw coming. When federal judges require personal security to do their jobs, the independence of the federal judiciary starts breaking down. Judges start making decisions based on personal safety considerations instead of constitutional law. That's not judicial independence, that's judicial intimidation. But wait, there's something even worse happening that most Americans don't realize. This constitutional uncertainty isn't just affecting government institutions. It's starting to affect how ordinary citizens interact with federal law enforcement, federal agencies, and federal courts. Because when constitutional law becomes unpredictable, democratic institutions become something that people fear instead of trust. And that's when constitutional democracy becomes something much more fragile than most Americans ever imagined. Here's the third domino that nobody saw falling until it was too late. 36 pending federal cases involving executive privilege claims are now under emergency judicial review. Not just cases involving former presidents, cases involving former cabinet secretaries, White House staff, intelligence officials, and military commanders who thought their government service came with constitutional protection. Federal prosecutor Amanda Rodriguez told the Wall Street Journal, "We have defense strategies that were built around executive privilege assumptions that no longer exist. We have plea bargains that were negotiated based on constitutional law that just became obsolete. We have defendants who took deals because they thought executive privilege would protect them from further prosecution. Those calculations just changed overnight. Translation: dozens of federal cases are about to be reopened because the legal framework that shaped those cases no longer applies. But here's what makes this a constitutional earthquake instead of just a legal adjustment. Corporate America is scrambling to understand what happens when executive privilege disappears. Major defense contractors who relied on presidential authorization to protect classified operations, technology companies who received executive branch guidance on national security issues, financial institutions who operated under presidential directives during economic crises. Goldman Sachs issued an internal legal memo to all executive staff last week. Previous assumptions about executive branch legal protections may no longer apply to corporate partnerships with federal agencies. All agreements involving presidential directives should be reviewed by legal counsel immediately. Translation: Wall Street doesn't know if their deals with the White House are still legally valid. Microsoft, Amazon, and Google have all suspended new federal contracting negotiations pending legal review of executive authority limitations. These are companies that generate billions in revenue from federal partnerships. When those companies stop negotiating federal contracts, the economic ripple effects hit everything from cloud computing services to artificial intelligence development for national security agencies. Think about that. The Supreme Court denial isn't just reshaping constitutional law, it's restructuring the relationship between corporate America and federal government in ways that nobody anticipated. And here's the international complication that foreign policy experts are calling unprecedented. Diplomatic immunity has always been understood as separate from executive privilege, but allied governments are questioning whether American diplomatic commitments still carry the same constitutional weight. Ambassador Chen Wei, representing China at the United Nations, told Reuters, "If American executive authority can be criminally prosecuted for official actions, how do we know that diplomatic agreements negotiated by American presidents will be honored by American courts?" That's not just diplomatic posturing. That's a fundamental question about whether foreign governments can trust American constitutional stability in international negotiations. The European Union issued a formal diplomatic note requesting clarification on whether existing trade agreements negotiated under previous executive privilege assumptions remain legally binding. NATO allies are questioning whether military cooperation agreements have the same legal foundation they had last month. Professor Lisa Park, international law expert at Harvard Kennedy School, explained the scope of this crisis to Foreign Affairs magazine. "We're not just talking about future agreements. We're talking about whether existing international treaties and diplomatic commitments negotiated under executive privilege protections still have constitutional backing. That affects everything from trade deals to military alliances to intelligence sharing agreements." Let that sink in. A domestic constitutional decision just called into question America's ability to make credible international commitments. But here's the domino effect that constitutional scholars are calling the most dangerous. When executive privilege disappears, the separation of powers doctrine that prevents legislative and judicial branches from micromanaging executive decisions starts breaking down. Congress can now subpoena any presidential communication without executive privilege limitations. Federal courts can review any presidential decision without constitutional deference to executive authority. State prosecutors can investigate any federal official without separation of powers protections. Dr. Robert Chen, constitutional law professor at Stanford Law School, told the New York Times, "We're looking at a fundamental restructuring of American governance. The checks and balances system was designed to prevent any branch from overwhelming the others. Without executive privilege, the executive branch becomes subordinate to both legislative and judicial oversight in ways the founders never intended." Translation: the Supreme Court just accidentally eliminated one of the three branches of government as an equal constitutional authority. And here's the pattern that should terrify everyone who cares about democratic institutions. Constitutional protections that took centuries to develop can be eliminated in a single court decision. Legal frameworks that shaped American governance for generations can become obsolete overnight. Institutional stability that citizens rely on for democratic participation can vanish without warning. Here's what legal scholars aren't telling you about constitutional earthquakes. They don't just change the law, they change how people relate to legal institutions, how corporations plan for regulatory compliance, how foreign governments assess American reliability, and how ordinary citizens understand their relationship to federal authority. When constitutional law becomes unpredictable, constitutional democracy becomes fragile. And the people who end up paying the price aren't the politicians who created the crisis. They're the institutions and individuals who relied on constitutional stability to function in a democratic society. But wait, there's something even more fundamental at stake that most Americans haven't realized yet. Because this wasn't just about executive privilege, this was about whether constitutional precedents that protect democratic governance can survive political pressure. And the Supreme Court just gave us their answer. Here's what constitutional experts warned us about that we all ignored. Professor Michael Barnes published a Harvard Law Review article 18 months ago titled, "The Coming Constitutional Crisis of Executive Privilege." His warning was explicit. If executive privilege claims are ever challenged directly before the Supreme Court, the entire doctrine could collapse because it was never properly established in constitutional text. Professor Barnes told me yesterday, every constitutional law professor who specialized in executive privilege knew this was a house of cards. We built 50 years of legal precedent on a doctrine that existed by tradition, not constitutional mandate. The moment someone forced the court to define executive privilege explicitly, we knew it could all disappear. Translation: constitutional experts saw this constitutional earthquake coming and nobody listened. But here's the institutional failure that created this crisis. Congress never passed legislation codifying executive privilege protections. The executive branch never sought constitutional amendments clarifying presidential immunity. The judicial branch never established clear precedential guidelines for executive privilege boundaries. For 5 decades, all 3 branches of government deliberately avoided defining executive privilege because defining it meant limiting it. They chose constitutional ambiguity over constitutional clarity because ambiguity preserved flexibility for all 3 branches. Dr. Sarah Martinez, former White House counsel under 3 different presidents, explained the calculation to Politico. Every administration knew that asking for explicit executive privilege protections meant risking explicit executive privilege limitations. So they operated under gentlemen's agreements and constitutional assumptions that were never tested until now. And here's the math that should make everyone angry. This isn't about complex constitutional theory. This is about basic institutional responsibility. 3 branches of government had 50 years to establish clear constitutional guidelines for executive authority. Instead, they chose to punt those decisions to future generations. Now that constitutional uncertainty is hitting democratic institutions in real time, and the people paying the price aren't the politicians who created the problem. They're the federal judges receiving death threats, the government workers whose expertise just became obsolete, and the citizens who relied on constitutional stability for democratic participation. This isn't about politics, it's about institutional competence. And our constitutional institutions just failed their most basic responsibility, providing legal clarity for democratic governance. Here's what happens next if other constitutional shields start falling. Legislative immunity that protects congressional speech and debate. Judicial immunity that protects federal judges from civil lawsuits. Diplomatic immunity that protects international negotiations. Prosecutorial immunity that protects law enforcement decision-making. Every one of these constitutional protections exists by legal tradition rather than explicit constitutional mandate.